It is indeed a pleasure and honor for me to be amongst this august gathering, which is being presided over by Honorable Mr. Justice Mansoor Ali Shah, whose seminal judgments and vision on human rights, technology and justice, environment protection, additional dispute resolution have made rich contribution to judicial literature. Your Excellency's commitment to improvement in justice system and development of jurisprudence on many constitutional issues has been a source of inspiration to many. The historic judgment we are commemorating today was delivered by the court while taking notice of two grave violations of the human rights of minorities. One, as Faria just mentioned, the horrific bombing of the All Saints Church in Peshawar in 2013, in which 81 innocent souls perished. And the other one was the threats issued by the militants to Kailashi and Ismaili community in Chatral, where they were asked to convert to Islam or face death. Prompted by the aforereferred to violations, the Supreme Court initiated suo motu proceedings under Article 184(3) of the Constitution on the 22nd of January 2014. And after a number of hearings, a detailed verdict was delivered in June that year with 8 specific directions. I would like to go through the history since the delivery of this judgment and what has transpired since then. Its first direction was to the federal government, directing it to constitute a task force for developing a strategy for religious tolerance. The second direction was both to the federal and provincial governments to make curricula inclusive so as to promote religious and social tolerance. In its third direction to the federal government, it asked it to curb hate material on social media. The fourth direction asked the government to constitute an independent National Council for Minorities. The fifth was to form a special police force for protecting places of worship of minorities. Sixth was to ensure job quotas, which the government itself had undertaken, that they will ensure that every sector, every department will have at least 5% for the minorities. The seventh direction was to take prompt actions in cases of violations of any rights of minorities or desecration of their places of worship. Ladies and gentlemen, the eighth and the last direction was to the registrar of the Supreme Court, and which was that he'll open a separate file to be placed before a 3-member bench, which shall ensure that this judgment is given effect in letter and spirit, and the said bench may also entertain complaints, petitions relatable to the violation of fundamental rights of minorities in the countries. Unfortunately, after the judgment in the year 2014, the 3-member bench worked only for a year. And it was only in 2018, after an application was moved at the Supreme Court on behalf of the Human Rights Commission of Pakistan, Center for Social Justice, Cecil and Iris Foundation, after which the matter was taken up by the Supreme Court again. And this time, the court constituted a one-man commission headed by Dr. Shoaib Sadal, who was tasked with following up the implementation of the Minorities Judgment and to submit reports to the court periodically to apprise the court of the work done and also to seek directions from the court where the intervention of the court was required. Ladies and gentlemen, and Justice Mansoor, Honorable Mansoor, I am most happy to share that as a result of the court's active superintendence and monitoring, as well as Dr. Shoaib's efforts, a lot of good work has been achieved. To give a few examples, the provincial authorities in Lahore have reconstructed the historic Jain Mandir in the heart of Lahore, which was demolished by an angry mob in 1992 after the demolition of the Babri Mosque in India. Another mandir, again in Lahore, Neela Gumbad, is also being restored. Ladies and gentlemen, can you imagine this happening in today's Pakistan? And these restorations could not have been achieved but for the Supreme Court's active intervention. Supreme Court also took notice of the desecration of the historic Tehri Mandir in Karak district of Khyber Pakhtunkhwa, run over by angry mob over dispute regarding prayers and visits by the Hindu pilgrims. This mandir was not only fully restored and rehabilitated at the government expense, but hundreds of extremists were booked by the police of Khyber Pakhtunkhwa. Thanks to Dr. Shoaib Sadal, more than 3,000 acres of minorities' trust properties have been retrieved from the encroachments because of these proceedings. Similarly, on the pointation of rights organizations and illustrious professors such as Professor A.S. Nayyar, hate materials and stereotypical projection of minorities have been largely removed from the school textbooks. Although, of course, as Professor Nayyar has mentioned, that we still have this issue of heavy dose of religious material in compulsory subjects, which is a violation of Article 22 of the Constitution. But this matter is also pending before the Supreme Court, and we hope that this will be taken up in due course. Again, more than 30,000 posts have been identified in both the federal and provincial services, again thanks to Dr. Shoaib Sadal, in relation to the 5% minority quotas. And I am told that the governments, all the provincial governments, are working towards fulfilling those posts from time to time. Ladies and gentlemen, all the above good work was achieved because of the proactive participation of the Supreme Court. Moving forward, I believe that despite these achievements, there is a lot more that is needed to be done, and that can only be achieved if the Supreme Court continues to take an active role in the implementation of the judgment. Now, coming to the central question as to how to further improve legal proceedings for the implementation of the minorities judgment at the Supreme Court. In fact, I would say that even more important is a question as to how to improve legal proceedings in cases of minorities at the provincial high courts as well as the lower tiers of the judiciary. My view is that there is just one simple thing, and if it can be done, it can bring a huge and transformative improvement in the quality of justice. That thing is inculcating a sense of empathy in the judiciary. Judges need to decide cases of minorities with empathy and compassion. I would say that this trait is the most essential requirement that should be present in judges when deciding cases of religious minorities and perhaps other vulnerable segments of society, such as women, trans persons, children, blue-collar workers of various professions and industries, and most importantly, the ethnic and racial minorities in Pakistan, such as people from Khyber Pakhtunkhwa and the oppressed of the Balochistan, who have been historically wronged by the state. So, what really is empathy in judicial decision making? I would like to quote Professor Rebecca K. Lee of Thomas Jefferson Law School, who said, "The use of empathy in juridical decision-making means trying to picture the situations of parties and their perceptions based on their particular experiences, especially from a less privileged point of view. Demonstrating empathy thus requires individuals to be cognizant of their own predisposed positions, taking into account their race, gender, class, and other relevant considerations that have contributed to their specific life and career opportunities. Judges must then step outside their own worlds in order to consider different kinds of thinking and experience, particularly since individuals tend to empathize more easily and even reflexively with others like themselves. Judges are likely to make decisions that disproportionately benefit similarly situated and familiarly situated parties. Stepping into another's world as he or she experiences it means that judge must elicit the information needed to picture oneself in that person's situation. It is thus incumbent upon judges to put effort and thought into broadening their ability to empathize with those different from them." Now, the other equally important question is whether empathy can be learned at this stage. especially in the context of judges which are in their 50s or 60s. And by that age, they have quite firm views and predispositions about various matters and social issues. Ladies and gentlemen, the good news is that neuroscience says that empathy can be learned. A part of our brain called anterior insula is responsible for evoking empathy and other reactions such as expression of fear, anxiety, and happiness. And according to Dr. Grit Hein, not only children but also adults can adopt empathetic responses. Adults too are malleable and can learn to be more or less compassionate through observing others. In other words, empathy in an individual can be induced through learning from empathetic reactions and or behaviors of others. Ladies and gentlemen, in terms of the actionable steps which can be taken, I would say that judges, particularly from the lower judiciary, need to be sensitized towards the concepts of human rights and minority rights. Here, the rights organization can play a big role in terms of training and giving them statistics, examples of injustices being meted out by the minorities in the society. Moreover, the standards of appreciation of evidence, especially at the trial court level, need to be revisited, especially when cases of gender and religious minorities are being decided. I do understand that the Federal Judicial Academy is doing a great job in training judges of the trial courts. Perhaps courses and seminars on human rights and reports of NGOs documenting human rights can be made a permanent feature of the training and learning at the Federal Judicial Academy as well as the provincial judicial academies. And with utmost humility and respect, may I also suggest that such exposure towards human rights is also required for judges of the High Court and maybe Supreme Court. Lastly, and I conclude here, I want to say a few general things apart from my topic. Ladies and gentlemen, this dream of equality and non-discrimination, this dream of tolerance, peace, and general well-being of all people of Pakistan, as promised to us by our Constitution, is possible. Yes, the situation is really bad. Yes, we have a large segment in the society which is steeped deeply in religious extremism and intolerance. And yes, we also know how over the decades, repression and flawed policies of the military rule have brought us where we are today. But this all can change, and the first step in bringing about this change is believing that change can and will come. We have to really believe deep down in our hearts that this is achievable and that it will be, inshallah, realized in our lifetimes. If we believe that this is not going to happen, it will certainly not happen. My view is that this dream is achievable through a combination of strategic thinking and steps by the executive, the parliament, and the judiciary. All tiers of the state have to act in unison. At the individual level as well as at the institutional level, we have to keep our thinking and vision clear. We have to be honest with ourselves. We have to call out individuals, institutions, and political parties who have appeased extremists and who have used religion for short-term political expediencies. We have to stop our support to them. We have to embrace the path of resistance at all levels. We have to shun appeasement. Lastly, ladies and gentlemen, my view is that no matter what the situation, we have to carry on. We have to plod on and keep the struggle going and work towards the realization of the above goals. And in this journey, to keep our spirits alive, we need to celebrate the small victories and small steps which people like Peter Jacob and other similar organizations are taking in that direction. Thank you very much.